Hello everyone, this is Sachin Sawant, your UK immigration lawyer. Okay, so before I begin this live, Happy New Year to everyone. And just to start with, in this live, I will be, if there is an issue with the sound or something, please let me know. If the sound is okay, just give me a thumbs up or something. Uh, in this live stream, okay, I'm just looking at my notes. I'll be providing the latest UK visa updates and also brief answers to your questions about UK visa applications, including EU settlement scheme, British citizenship applications, etc. I will prioritize in the live whatever live questions come first, and secondly, the second priority will be for channel member questions which have been typed in the comments, and then any other comments, questions. If you stay throughout the live, I'll be giving important updates almost every 10 minutes or so. Let me set up a timer for the 10 minutes. And towards the end of the live, just a minute, I'll cover that part. Okay, towards the end of the live, I will be giving some updates on e-visa steps before you travel, graduate route, visa refusal, one of the important, something that has come up recently, updating your nationality on e-visas, and third, very important one, this is a common, not many people know that by the end, if you file an application and your application is refused, usually a points-based application, either a skilled worker, graduate route, student visa or something like that, then in that case, within 14 days inside the UK, if your application is refused, you can make another in-time application. So within 14 days of that refusal. However, that impacts a lot of things. I'll be discussing that towards the end of the live, is how 3C leave is affected, your right to work, right to rent, etc. Also, how it affects your long residence ILR. If you are planning to apply for 10-year long residence, indefinite leave to remain, how that period of book-entered leave, once your application is refused, you file another one, a new one is approved, how that period and what period affects and how it affects your 10-year long residence application in future, if any. So I will cover that towards the end of this live. What else? Yeah, other viewers have benefited a lot from previous live sessions and have saved costs on their immigration advice. If you need advice on your specific situation, hit the link in the description and book a paid consultation for yourself to discuss your matter. Okay, so to start with, if anyone is coming live, you can ask me your questions. And who is this? Okay, by the time I will take the questions on the channel in the comment section and answer them. Okay, let us see. I'll just prioritize the members' questions first. Let me find the questions. Continue. Community. Okay, I have a live question. Let me just read through. I'll take that one first. Just a minute. Ali, can someone work more than 20 hours since the Home Office has revoked his care company license? No, the answer is no. Sorry. We have queried this with Home Office, and Home Office this is one of the major concerns Home Office has. I know they are trying to work with everyone who has been affected by these care homes losing licenses. They are sending emails trying to ask you to contact DHSC, that Department of Social Services, try to give alternate employment or something like that, and not curtailing your visas. But one of the alternative, the converse of that is they have a concern that individuals whose sponsors have lost the license, they may be working somewhere else. Even that 20 hours is not allowed if your license is revoked, because as per the immigration rules, as per the compliances of the immigration rules for your skilled worker or care worker visa, you only get the 20 hours extra if you are working for your contracted hours with your sponsor. And when the sponsor has lost license, that is not possible. But in spite of that, everyone is working at least 20 hours. So even that 20 hours is in question. So definitely more than 20 is not possible. Sorry about that. Hello, Babakar. Okay, Rafi, over speeding .3 on driving license, will it affect ILR refusal? It is out of court disposal. ILR refusal. I don't think it would be refused, but I think I remember one case where someone had been driving without insurance and that person's ILR was delayed by 3 years. So I think it stays on your, if it is within the last 3 years, yes, it would affect. You would have to wait for 3 years to pass to file your ILR. That is my understanding and interpretation of the rules. Okay. So it affects up to 3 years. You can still apply for permission to remain, but indefinite leave to remain is not allowed up to 3 years from the point you do any out of court. I don't think speeding points would affect. Let me think. Driving without insurance is quite a big matter. Even driving under the influence of alcohol is a big matter. It is a tricky one. I don't think .3 should be 3 points. 3 points, when do you get it? If you do, even if you speed over this limit, you would get it. Yeah, if you don't have any, so the way I would put it is, if you go to, so for example, I've also, recently in last almost, I don't know how many years, 26, almost 8 years of my driving history, for the first time I got a driving speeding awareness course. I was sent to it. I was 34 in a 30 zone. Yeah, something happened. Yeah, so I think such a matter, so there are two ways how you deal with, if you have been gone to a court. So for example, whenever that speeding letter comes, if you got it for speeding, yeah, you got it for speeding, I see that. So if you attended the course of study, I think they gave you two options. One is you attend the course of study, or if you want, you can go and contest it with the judge, and then if you lose there, then you get, then it becomes a conviction. So I think if you have fought it in the court of law and you have argued saying that no, I did not speed, and after that you got the points, that may affect your ILR. So if that is the case, it's a very specific situation, but yeah, we need to take all the facts of your case, but this is just a brief idea I can give you. But yeah, usually you don't get points unless you do contest it. That's my understanding of it. Okay. But usually consult an immigration lawyer, give the details, facts of the case, what has happened, and then the immigration lawyer should be able to advise you. Yeah, you can book a consultation with us or go to any other immigration lawyer. Mohammed, sir, I am an immigrant. I came 8 months ago and my wife is in Bangladesh. So how can I tie her here? Tie her here? What's the time period and cost? What visa do you have, Mohammed? Only then I can answer your question. Rumil Modi, sir, my PhD was expired in October, then applied fee waiver, which was rejected, and now I'm on FLR. Can I switch? Fee rejected. FLR. Can I switch to sponsorship? Sponsorship all applications in given time. Already got costs. It is a tricky one. Yeah, we usually fee waiver rejected. I am assuming you filed the FLR within 10 days of the fee waiver rejection. So on that basis, you may be able to vary your application of further leave to remain to a skilled worker application if you are meeting all the eligibility requirements. So in the first instance, from all the facts, if you file your application FLR within 10 days of the rejection of the fee waiver, then you may be able to vary your FLR to a skilled worker application. But please book a paid consultation with us, or to confirm our advice, I need all the facts of the case. Only then I can confirm that. But I think in the first instance, yes, I think that is possible. Roshan Shrestha, sorry if you don't want, if I don't want to study, or if I get a misconduct on my course, what is there any option if I want to move to another country? Sorry, I can only advise on UK visas. I don't practice any other country's laws, so I don't know about other countries' laws where you want to consider moving. Okay, so Mohammed, you are on a skilled worker visa, migrant. And Mohammed, I'm assuming you're not in one of those care sector job codes, 6135, 6136, one of those. So if you are on those job codes, and 8 months ago, 8 months means So December minus 8 would be April. So if you are under the old rules, you may be able to sponsor your wife from Bangladesh. You should be able to on a skilled worker visa. But if you applied after the rules changed, then you may not be able to sponsor only if you are in one of those care worker job codes. I think 6135, 6136, one of those. Other than that, you can sponsor your dependent partner. Okay, no other live questions now. I'll go to the community tab. Let us see members. Sort by. Okay, so I'll take the members' questions that I have over here. Okay, Drumil, chances of interview and priority or super priority visa. Chances of interview. They have started investigating in-country skilled worker applications. I did cover that in my previous live. They are asking for a video interview or something if they are not happy with something or they want to clarify some things. Yes, they may. In your case, it is possible, as you have been buying time, it looks like from your applications, it is a possibility that they may, yeah, interview you. Convicted by the magistrate, sentenced to 140 hours community service, placed on this rest for 5 years. Will that affect my submitted EU settlement scheme application? Yes, you were convicted and you were giving out of court disposal and placed. Yes, from the first reading, Abdul, whatever you have told me, it would affect definitely if you apply for a settled status. Uh, I'm not sure whether which application if you file for a pre-settled status may not be affected, but a settled status application usually would have effect of such convictions. That is my first reading of the law and interpretation of it. But yeah, speak to an immigration lawyer, give all the details, all the facts of your case, and then get advice on it. But just to briefly answer your question, it may affect. That's what my first understanding of it is. Okay. Okay, there are some questions from members on the channel. I'll take them. In the meanwhile, if anyone comes live, you can ask your questions. So, is a person on skilled worker visa eligible to get personal allowance transferred to for tax purposes from the dependent who is a homemaker, marriage allowance? Is there any violation of skilled worker status or ILR in future? Okay, the question is about skilled worker visa holder, husband and wife. So, wife is a dependent. I'm assuming, I'm just taking that example. So, this member has asked, he's on a skilled worker visa. There is that personal allowance. It is more a HMRC question, it is not a home office question. So I may not be able to answer exactly, but I don't think that would be allowed because with the skilled worker visa, your taxes are deducted at source. So at the point when the salaries are being given to the skilled worker, there is a live reporting by the, that's how I understand. Every month the reporting has to go to HMRC and the taxes need to be paid, whatever, national insurance, etc. So I don't think that is possible, but I'm not a HMRC or tax expert. You should consult an accountant and they would be able to tell you. But in my opinion, if you're asking about whether that would have any impact, firstly, I don't think that would be allowed, number one. But then even if that is allowed, I don't think it is in the spirit of skilled worker visa. So it would have some impact on your indefinite leave to remain in future. Okay, next question I have is from Himal. Okay, so I think you asked two questions. Sir, I am failed in dissertation. I applied for sponsorship. UKV asked me for course completion letter. Failed dissertation. University did not give me the letter and my course end date is 20th September. You asked the question 2 weeks ago, so about December. Okay, the question is from Himal, who is a member. Okay, 10 minutes up. I'll give one update. What do I have? Okay, so one of the updates is about endorsing bodies. Endorsing bodies for this Innovator visa, Innovator founder and scale-up visas. Innovate in Britain, this is one of the endorsing bodies. So this is one of the discussions through Immigration Law as a Practice and Association we have discussed with Home Office. So Home Office has, we asked them, Innovate in Britain has some issues going on. I think they have stopped endorsing people. There is something, Home Office is not happy with them. It is not very clear. So Home Office was unable, we questioned them on whether what happens people who have already been endorsed, etc., etc. So the Home Office team was unable to comment or provide details about Innovate in Britain. They didn't give a proper update. Britain's suspension, so that body, Innovate in Britain, has been suspended. They cannot endorse anymore. That's what is the latest that I know of. Due to ongoing discussions, they are having some discussion with Home Office. Cases endorsed by Innovate in Britain are currently on hold. So any cases, any individuals who have filed Innovator founder visa, scale-up visa, etc., and that has been endorsed by Innovate in Britain, they are on hold. They are not being decided, which they hope to take up by the end of the next week. So yeah, they will be looking into it shortly. They want to make a decision and decide what they are going to do. The Home Office appreciated the impact on individuals and that the situation was not optimal for the applicants. The Home Office assured that if any action is taken regarding Innovate in Britain, at this time they could not comment on the likelihood of that. Transitional provisions would apply to allow affected individuals to secure an alternative endorsement. So they will give them alternative opportunity to get endorsement from some other endorsing body. The Home Office referred to the existing rules under which applicants must be issued an endorsement letter no more than 3 months before the date of application. Yeah, so that's Innovate in Britain. There are some issues going on. Their right to endorse individuals has been suspended. Any applications filed with their endorsements are on hold, and whenever Home Office decides on them, whether they cancels them completely or whatever they do, individuals will be given an option to get alternative endorsement from some other endorsing body. Okay, so that is the update. Let me set up another timer for some time. Okay, so on the next buzzer I will give another update. So I have a question from Rahul. Okay, Rahul, thank you for being a member. So your question is, if someone is working with the NHS Foundation Trust on Band 2 as a medical laboratory assistant and the person is on their graduate visa, are they eligible for a healthcare visa? Are they eligible for a healthcare visa? So if someone is, so that is mainly for your trust to decide whether your job category, so that is where the employer has to check mark on the cost saying healthcare visa yes and no. So it is for the employer to decide. But if you are on that, let me try to find it for you. Visa UK job codes. If I can find it, let us see. What is the job codes? Your job must be in one of the following. Okay. If you know your job code, if you can tell me, I should be able to answer that in a yes or no. Medical laboratory assistant, I'm not sure. Let's see. Medical laboratory assistant. Medical. I don't think that is on the list. I'm looking at the list of occupations. Your job must be in one of the following occupation codes to qualify for health and care worker visa. So I don't know your exact job code, but from the name I have tried to search. I don't think it is in the healthcare occupations list, health and care worker visa. So yeah, the answer is no. So you may not be eligible for the health and care visa. Hello sir, can I apply human right case? My wife's skilled worker and I have a baby as well, so I can apply human right on skilled worker wife and baby 3 years in UK, born with Indian passport. Yeah, all these, unless your child is, so your child is born in the UK, but 3 years. It is a difficult one with 3 years. I don't think Home Office will give you. I have to tell you straight away. I don't try to sell things over here. So I know there are other lawyers who will go to and they will say, yes, you have a case, and they will just file anything. I know they will do that. There are many such weirdos who will do that for money. But I don't think with 3 years, just the child being spent in the UK, I don't think you have a case at this time. You may have to continue living as an overstayer or my wife's skilled work visa. So you already have a visa. I don't know why you want to apply for human rights. If you have a valid visa, continue on that. But then if your visas have been cancelled, curtailed, whatever has happened, you may have to live as an overstayer in the UK. But I don't think you have a case of human rights at this time. What do Home Office want us to do? Since all has been revoked, we need to pay bills. They're saying we should not work. Yeah, so yeah, that is something I think you need to ask Home Office what they want, but they always go by the rules, whatever that is. So they are the best thing that Home Office. So at least they have agreed not to curtail your leave. So you should be grateful or thankful that they are not curtailing your leave. They have the option to do that. The immigration is allowed to do that, but then they are trying to be reasonable over here. But then at the same time, they need to talk of the compliances of the skilled worker visa also. If they allow you to do anything, everyone else in the skilled worker will also ask to do anything and everything. So they need to go by the rules at least. So I think anyone who is in that situation, you should be at least grateful that Home Office is not curtailing your visas and asking you to leave within 60 days, where your sponsor license has been revoked. So yeah, you can. Rahul, so code 3111. Okay, so I have it here 3111. I don't think it is 32311. Okay. I see over here that says 3111 is laboratory technicians. So if you are under this, yes. Under this one, 3111 laboratory technicians, that is the job code name that I see over here or similar names. In that one, yes, you can be sponsored for a health and care worker visa. So that job code is there. Okay. So next one. So Himala Podel. So she failed the dissertation, applied for sponsorship, and UQA asked for course completion. Okay, yeah. Any student who wants to switch to a skilled worker visa, so she filed it. They're asking for a course completion letter, but university did not give me a letter. She failed the dissertation. My course end date is 20th September. If you file this application through a lawyer, maybe, yeah, they should be able to explain the rules and define your situation to Home Office. Your application should be approved. I don't see any reason because you have completed the course of study, though unsuccessfully. The rules don't say that you should complete it successfully. So unless you have been debarred from the university, etc., that's a different matter. But failing a dissertation is not completing the course. So you have completed the course but unsuccessfully. Yeah, speak to an immigration lawyer and get advice on this. If you are still in this process, I think you queried this some time back. But then I think you should qualify. They cannot refuse on that point. You may be able to submit them the CAS letter, which should have the course end date at least. So if you have a lawyer, maybe they should use the CAS letter and explain and represent it to the case working team and tell them that the course has been completed, though unsuccessfully. So because the course end date has passed in your case. Your next question is, what documents do I need to apply for skilled work visa from the university? Visa from university. I have failed my dissertation. Yeah, the best document is get an email or a letter confirming that you have completed the course of study. And even if they say you have failed the course of study, that's perfectly fine. That is not the requirement in the rules to switch to a skilled worker visa. So an email or a letter from the university confirming that you have completed the course of study, that will be helpful. Okay, so all the questions from members are done. I have another live question. I see. Where is that? Okay, I'm in Indian citizen. Recently applied for naturalization. Do I need to renounce? Do I need to renounce my Indian citizenship if I'm granted UK citizenship? Yeah, you don't renounce your citizenship. I think I had Indian citizenship before. So yeah, you have to surrender your Indian citizenship. That's what India calls, I think. Yeah, so you need that. First, you get the UK citizenship, you get the UK passport, and after that, you apply to surrender your Indian citizenship. That's how India uses it. I cannot advise on Indian laws, but yeah, I have done it myself, so I know that. I'm an overstayer and my wife got skilled worker. You're overstayer, wife got skilled worker and baby as well. You are overstayer, wife got skilled worker, baby as well, 3 years. Yeah, Sunny, you asked the same question again. Yeah, there is very less chances of success in case of an appeal also. If you file that, whichever human rights application, if anyone is promising you that. I would advise not to file any applications. You are an overstayer. If you get on the list, they get behind you and they may try to remove you. So I know other lawyers will just make money, file your any application saying, human rights application saying, yes, you have a very good case and this and that. You will be stuck with it. Once they refuse the application, Home Office will start running after you to make sure to uh, administratively remove you out of the UK because you are already an overstayer. So I would advise not to file any applications unless your child turns 7 years of age, at least as per the current rules. Okay. Community. Okay, I'll take some questions on the channel for now. Okay, so I'll take it in the order of receipt, whichever is being received the latest. I'm taking that because those are the ones that would matter much. Older ones, I know people may have moved on with their situations. So Alex Christian has asked, I did not apply for e-visa. What should I do? You should apply for an e-visa. That's the only answer I can give. Yeah, if you have not applied for any visa, you should apply for it. Nitin Sharma, I'm doing masters in UK. My wife is British. Can I apply for spouse visa before finishing masters? So switching from student visa to a spouse visa. So Nitin Sharma's wife is British. This is a common one. Home Office coming across these situations a lot. One of the important things, yes, you can switch, because if you're switching under a human rights application, which is the spouse visa, you can. Home Office cannot say that. You have to complete your course of study, provided your relationship is genuine, you are meeting all of the requirements, financial requirement, accommodation, English, etc., for the spouse visa. So yes, you can switch. That is the answer. But you may be investigated. Your passport may be retained. Highly likely you will go through the service and support center. You can see my other visas on the passport retention aspect. If you're switching from a student visa, this is one of the high risk ones where frauds are happening. So Home Office may retain your passport when you go, and you may be asked to go through the service and support center, to the best of my knowledge. Or yes, and they may call you for interviews or do some sort of investigation. So yes, you can file it without completing the course of study. Students can switch because spouse visa is a human rights application. Next. Okay. I would like clarification regarding continuous absences. For example, if I plan to spend 90 days in my home country within a month period while working remotely, that would be acceptable. Okay, the question is on absences, effect of absences from the UK on indefinite leave to remain on skilled worker visa. So indefinite leave to remain on skilled worker visa. So there is one video where I think I'm explaining about 180 days outside the UK in any 12 months. So the rules for skilled worker ILR is that you are allowed 180 days of absence up to 180 days in any 12-month rolling cycle, not a calendar month, Jan to December. It's a rolling cycle from the date of application backwards, from the date of your ILR backwards. So on that, uh, up to 180 days in any 12 months absence is allowed. The question he has asked is, Srinivas, I would like clarification. If I plan to spend 90 days in my home country within any 12-month period while working remotely, would that be acceptable? That should be fine because it is 90 days. It's under 180 days. My employer has confirmed that you are permitted to work. That is not relevant. For the absence perspective, the main thing that matters is the number of days you are present or absent. Yeah, so, and additionally, do I need to account for this extended period of absences when applying for ILR? Yes, you have to fill up on the form all your absences from the UK, and if it is within the 180 days, in your case, it would be 90, it would be fine. Okay, there is another live question. Where is that? Rana, 9 December visa, fill but not reply. Now I am waiting 23rd December interview. So I'm assuming you submitted the application on 9 December, 23rd December you were interviewed. What visa is that? If you can tell me what is the visa category you applied for, skilled worker, student, what is that? And was it applied inside the UK or outside the UK? Kishan Acharya, is there any usual delay? Is there any usual delay in processing of skilled worker applying from inside UK? I applied on 14 December priority basis. No, there is no delay that I've heard of. We've also filed applications on skilled worker priority. It should be decided in 5 working days. So if that is what you applied. I resigned from a skilled worker job and sponsorship was withdrawn. It's been over 60 days, but I've received no curtailment. Will this count as an overstaying and affect my future ILR? No, it wouldn't count as an overstay and would not affect your future ILR. My brother went on a healthcare visa, later he got sponsorship and he filed visa. Later visa rejected because of overstay. After he left UK within 22 days on his expenses. Any ban on him? Yeah, after the refusal, if he's returned back to out, he's left the UK within 22 days, there should not be any overstay ban. I'm just answering on the point of the 22 days of overstay if you're talking of. No. If the overstay is more than, I think, 90 days, if it's 90 days or more, then 1 year ban would come into play. But 22 days of overstay should be fine. Okay. Next question. Thank you. Okay, Jasper Singh question on the channel. It helped me a lot. Okay, thank you. What if person holds EU settlement status when the relationship breaks down? Does it affect the person's right to stay? Yes. So this question is on the EU settlement scheme. So Jasper is asking, he's on a EU settlement scheme, and if the relationship breaks down, what does it affect the person's right to stay? Technically, it does. Basically, unless. Okay, time for an update. I'll just complete this answer and then give another update. So yes, it would affect your EU settlement scheme status if your relationship breaks down. That's my summary answer. Depending on the facts of your case, you may be eligible for retention of rights, you may not be eligible. Speak to an immigration lawyer and take it from there. Okay, another update. Where is that? So this one is done. Okay, so another type of leave has been, so from the 10-year long residence, Home Office has taken out one more type of leave. I think earlier in the year, they took out the visitor leave. So anyone who spends any time on the visitor leave, it breaks their continuity of residence in the UK. That was added earlier, I think almost a year now. And now individuals who are on the Ukraine schemes. So the Ukraine scheme was just a temporary situation, which the Home Office drafted the rules immediately and it brought into play. Individual staying in the Ukraine scheme will no longer be able to use their time in the UK under the scheme to qualify for settlement through 10-year long residence. So if you are trying to apply for 10-year long residence, throughout the 10-year period, you should not have spent any time on any of the Ukraine schemes. There were several schemes, Homes for Ukraine, etc., etc., different names, but it was a Ukraine scheme visa to help the individuals who were affected by the war situation. So yes, any permissions, any visa period spent on the Ukraine scheme cannot be counted towards a 10-year residence, and Appendix Ukraine scheme will be added to the list of excluded routes for qualifying period requirement contained for a permission on the long residence route for settlement on the long residence. Therefore, permission under Appendix Ukraine scheme will retrospectively break the continuity of a 10-year qualifying period. So if an individual has spent even a day on the Ukraine scheme, that day would break the continuity of residence for the 10-year long residence application. So that is the second update for today. There are some live questions. Let's go there. Woman kids vlog. My brother went okay that when I answered England. When I checked my UKY account, the company solicitor's address was mentioned as postal address. UKY account, postal address. If the curtailment letter was sent to this address, will that he consider as an overstay? Yes. So usually the curtailment letters are not sent. Usually emails are sent nowadays. To the best of my understanding, Home Office is saving on resources. I don't think they're sending letters. I'm not seeing letters for a long time now. So usually if your email is updated, they should send it to the email. By mistake, sometimes they may send it to the authorizing officer of the sponsor license, your employer also. But mainly the way you should check it is, if you want to check your status, go and check your visa status, that is a digital status, log into your e-visa and see. If they curtail it, your date changes. I have seen those. So whatever your visa period was, let's say they issue a curtailment letter today, your visa period will be ending. You will see the visa period is changed. The end date is changed to 60 days from today. So that is the best way to check it rather than waiting for the curtailments. If you are concerned, check it every day, every week. Yeah. So whatever, that does change. I have seen that several times. So that is the best way to check it backwards. It will still be an overstay. It doesn't matter if you have not received it. Once they've issued it, yes. To answer your question, yes, it will be an overstay, because once the notice is issued, your leave is curtailed. You can also check it from your e-visa. So that is not an excuse for you. Ali Raza, sir, I'm right now on PSW. Want to open a restaurant? Can I eligible to open a business on PSW? Yes, you can. You have full rights to work in the UK. Yes, the answer is yes. But make sure, yeah, for your future, you may try to get onto a self-sponsorship visa and all. For that, speak to an immigration lawyer. Home Office has been refusing these applications of self-sponsorship in the last 3 to 4 months. Left, right, center, almost all of them, they are refusing these applications. They have got to it now. So yeah, if you're planning for your self-sponsorship and all, speak to an immigration lawyer, see the viability of the business, the genuineness of the job, very, very important. That's where Home Office kills all these applications. They come up saying there is a question on the genuineness of a vacancy. Genuine vacancy is where they fail it. That's what I've seen. So speak to an immigration lawyer, book a consultation with us or any other immigration lawyer, and discuss the facts of your case if you're considering that self-sponsorship. But yes, you can start a business on PSW, graduate route visa. Okay, I've answered this one, I've answered this one. 1 hour. So 37. Okay, I'll take some questions on the channel and answer them. If a senior care worker, see if senior carer 6136 from 22 onwards age. Okay, Madheshwaram, hi sir, I switched my visa healthcare to skilled worker visa last week, and last week is my visa approved. Last week visa approved. Healthcare dependent only. I can apply for my wife next month. Okay, so let me understand your question clearly. Hi sir, I think I will save you a lot of money from this live. Definitely become a paid member, and with that £1 membership or whatever that is on our channel, I'll save you considerable cost. I understood your question, but I will still read it again. Hi sir, I switched my visa. So you switched from a healthcare visa to a skilled worker visa. Your wife is a dependent on your healthcare visa. So you had a healthcare visa, on that you have your wife which is dependent. Now you switched your visa from healthcare to skilled worker, whatever you change your job code. For my purposes, both are skilled worker visas. And last week, your visa is approved. Now my wife is still in healthcare, visa dependent only. I can apply for my wife next month. You don't need to switch your wife's visa from healthcare dependent to a skilled worker dependent. She is still a PBS dependent. You should say PBS dependent partner, something like that it should say on her permission. She is still a dependent of a skilled worker, whether a healthcare worker or not. So she can continue living in the UK till the expiry of her current permission, and in the last 28 days or so she can extend her visa as a dependent, because she is still your dependent. Don't waste your money just applying. If she still has valid permission, which is considerable, if it is just expiring in 2-3 months, yeah, you may do it now. But if she has permission longer, you should not waste your money applying for her application now. Yeah, I saved you a lot of money if you were planning to apply for your wife's dependent. Okay, so she is not required to. She is still a dependent partner. She is a dependent partner on a healthcare visa, main applicant, and now she is a dependent partner on a skilled worker dependent. Both are skilled worker categories, they come under the same rules. Still a PBS dependent partner, points based system dependent partner. So, yeah, you are not required to file it now. Next question on the community channel. Let's see. Vineet, if senior carer 6136 from 2022 onwards change to 6135, okay, with new employer, okay, who already in UK, is allowed. Yes, so the question, I understand it, I'll just rephrase it. So Vineet is a senior carer 6136 in the UK since 2022, that is before the changes of this year, April 2024. So you are under the old rules. You can change to 6135 job code with new employer, with the same employer. I don't care. You can switch. You are still under the old rules. So, and yes, you are allowed to switch, and you can do that within UK. I think that is your question. Onwards. I'm trying to interpret the question, what you're trying to ask me. With new employer dependents who already in UK is allowed. Yes, because you are still under the old rules on the skilled worker visa. So if you switch employer and also change job codes, then your dependents can continue living in the UK. If you are asking about dependents, I will answer that part also. So with the new employer also, your dependents can continue living if they already have permission, as I just answered someone else's question. Yeah, Mateshwaran's question. If they already have permission, they can continue living in the UK. If their permission is ending, then yeah, they should extend it. But yes, you can sponsor them because you joined the care worker area, skilled worker area before the new rules came into play. Okay, so next question. How long should it take to receive another mail, NSF email, my bio on 20 December? Okay, so this is someone talking about UK student visa embassy interview. Okay. How long should it take to receive another mail after NSF email? Sorry, I'm not sure what is the full form of NSF that you are referring to. My bio on 23rd December. Your biometrics were done on 23rd December, 24th December. NSF till now no update. So I think you're talking of a student visa. 24th December. I think usually standard student visa decisions should come within about 15 working days. No, 1, 2, 3. 10 working days. Yes, 10 working days. So about 15 calendar days approximately. But there are many holidays in December. So maybe you should account for that. So if you enroll your biometrics on 23rd of December, if I have to count 15 minimum, so 23 plus 7, 8. So maybe at least you should wait till 7th or 8th of Jan. That's what my calculation for a student visa should be. Okay, next question. My wife is on skilled worker dependent visa. She is working as a housekeeper. Okay. Okay, live questions. To show my genuineness, can I buy a shop, a place for restaurant business even on PSW? Yes, you can do that. But that doesn't prove the genuineness. So just investing money does not prove genuineness. Yeah, there are several aspects to it. Sorry. But yes, you can do that. You are allowed to do that. How to say my job is in a SOC and is on SOC. Skill occupier. Okay. I came in April 24. My course was issued before 4th April. Yes. Now, if I switch employers, do I have to meet the new salary requirements or am I exempt? Yeah, you still, since you filed under the old rules, your course was issued under the old rules, and your first visa was granted under the old rules, you can continue under the old rules. But remember, the minimum would change. At the time when you applied under the old rules, the minimum salary was 26,200. So now you would at least need to be paid at least 29,000, the base amount of the salary. The 38,700 doesn't apply, but a base of 29,000 will apply to you, because the base of 26,200 has shifted as per inflation, etc. in the UK. So it has moved to 29,000. But you come under the old rules. So, my wife's on a skilled worker dependent visa. She's working as a housekeeper in a care home. If she's eligible for IHS refund. Skilled worker dependent visa. My wife is on a skilled worker dependent visa. NHS refund. So the questions is about someone. So Banu JGL, your wife is on a skilled worker dependent and she works in as a housekeeper in a care home. I don't think she would be eligible for a refund. That is not one of the occupations that NHS refunds. NHS, I will check anyways, for healthcare workers in UK. I doubt whether I'm trying to find out if the job code is there, but to the best of my understanding, I don't think so. Let us see. Yes, my first understanding is I don't think she would be eligible for IHS refund. Okay, live question. Okay, thank you, Mohammed. England Kabaddi. Following up on your previous answer, I checked my e-visa and the date of the end of sponsorship is still the old one, which is 2029. Should I consider this as the curtailment has not issued? Yes, that is correct. The curtailment is not issued. Yeah, you checked it right now. Good. When the curtailment is issued, the date will change. I have seen at least 5, 6 of them myself. Skilled worker, student curtailments, every curtailment I have seen. So Priyanka Kala, I'm on extended. So Priyanka, I'm on extended spouse visa. Extended spouse, living with my husband who is UK citizen. To bring my mom on visiting visa, is it necessary? Money should be in her account. Can I show up money in my account as a sponsor? You can show the monies anywhere. Home Office doesn't care about that. The point is, anytime you bring an adult dependent relative in the UK, they will see the facts of that person's case. You can pay for the entire expenses, that person can pay. That is not very much relevant. That just has 5% or 10% of the weightage. 90% of the weightage is they have to focus whether that person will return back to their home country. For that, they will assess their ties back to their home country. One is their financial ties. Those are the important ones. How much savings they have, assets, property, any job, if they are doing any job or receiving any pensions back home. So any financial ties, assets, everything, you should show that. Transferring monies, depositing monies is a bad thing. I have another video where I have referred to it. Is somewhere I have done it more than a year now. The problems with the deposits, financial huge deposits in the applicant's bank account. So don't just deposit monies into your mom's account to file an application. They will question it, they will refuse the application, just saying we have seen some random deposits coming in your account and we don't believe all your whatever you're saying about your finances is genuine. It's a common reason for refusal. So you need to show her finances and her financial ties mainly, and other ties. If they are relationship, any other children, birth certificates, their IDs, financial ties, social ties. If your mom is attending any religious place, temple, church, mosque, get a letter from there. If she's a member of any body, society, anything. So try to show all the ties, social ties, relationship ties, financial ties. That's what they concern, and mainly it is financial ties. Yeah, so that's what I would say. England, buddy. Thank you so much. I appreciate it. Okay, thank you. I have an e-visa. I have visa against skilled worker. I have visa against skilled worker with leave till May 25. Okay. My passport number has changed. Meanwhile, is updating in e-visa now. Okay, as it doesn't have a chip, or shall I update during visa extension application? You can. You should always update your latest passport. That's what Home Office recommends. But if you are not traveling outside the UK, this will be a problem if you are entering the UK May 25 till 31st of March 2025. It is perfectly fine. You can also use your expired BRP to show it to them because that is allowed. But between 1st April to till the end of your visa in May 25, if you are going to enter the UK, then I would say update your new passport. You should. If not, yeah, you can update it at the later stage when you are filing an application. Thank you, Priyanka. So yeah, no plans to travel. That's perfectly fine then. No need to update. I think yeah, it should be okay. So this one is gone. Let's see another one. So next question, Kareem. I work full-time job. I'm relying on fixed basic income plus overtime hours to meet the financial requirement. Would that be considered as fixed income or variable income? The question is about spouse visa financial requirement. Currently, the new financial requirement is 29,000, which changed last year. Yeah. So if you are meeting the financial requirement for a spouse visa, so Karim is asking, he's in a full-time job and he's relying on fixed income, so which is the fixed component of his salary and overtime hours to meet the financial requirement. Yes, that is allowed. That's not a problem. Would that be considered as fixed or variable? It would be considered as variable income. He's talking of the immigration rules. So in that you have the A and B categories. So yeah, my answer is it's considered as a variable income. You need to show your whole last 12 months of income earned with bank statements, slips, employer, covering the whole last 12 months period. Okay. So next question, Myra has, I have a question. Yeah, please ask your question. Okay. Hi, I'm British citizen. To leave to my native country, to look after my mental health and my parents. It's been 3 years. I haven't returned. Am I in trouble? British citizenship absence 3 years. No. So the question is from Queen Olivia. So she says that she is a British citizen and she has spent, I think, about 3 years or so outside the UK for some mental health reasons or parents. After my mental health, my parents. Okay, so that's not a problem. British citizens can spend as much time outside the UK. You are not in trouble. So your question is, are you in trouble? No, you are not in trouble. Okay. Spouse visa. My wife has given has given fee waiver application from England. It has been 6 months. When will they reply? Fee waiver applications are about, there is no timeline basically of fee waiver applications. Currently about 12 months or so is the processing time for currently. As per the current processing, it may take up to 12 months. I know some of these students and all graduate holders, PBS applicants who are filing, they may get a rejection within 3 months, even 1 month, because Home Office is sorting them and just whatever frivolous applications are there, they are sorting them quickly. But all those human rights based where they have a genuine case relationship with a British citizen, they are in the normal queue. It may take up to 12 months. May I ask, after 2 years re-entry ban is finished, is there any chance to get skilled visa if there is employment? So Iluj de la Cruz, his question is, may I ask if the 2 years re-entry ban finished, so he had a 2-year re-entry ban for whatever reasons, is there any chance to get skilled worker visa? Yes, if you have a genuine employment, genuine sponsorship, it is possible. You will definitely be investigated. I can guarantee you that. You may be interviewed, etc. How you find the job, genuineness of the job, genuineness of finding the job, left, right, center, you will be investigated. But yes, if everything is genuine, uh, you should be fine. You should apply then. So Nitin Kumar, hey, I hope you're doing well. I got married in UK and my partner is British. I'm doing my masters. Can I convert my student into a spouse visa before completing masters? Yes, you can convert. I think I answered this question. You asked this question twice. Okay. Hello sir, I have an e-visa. I have e-visa, but I lost BRP card. So my question is that card need PSW? Okay, so Jiva, I have e-visa, but I lost my BRP. Question is that card need for PSW? I came 12, 24 December 2023. It's lost yesterday. So 5 days ago he has lost it. No, I don't think you can file future applications with even if your BRP is expired, because it is anyways. But you may not be able to use the ID check app or something. You may have to go through the application and appointment process, but you should be fine. Anyone who has lost BRP card and has an e-visa, it should be okay. You can file you don't need the card for applying for your PSW, graduate route visa. I don't have BRP, BRC, but I have an email from office for e-visa, how to apply. Okay, sorry, on this live I cannot go step by step on how to apply. If you Google search for apply for e-visa, I think there is also a YouTube video that Home Office has very well explained how to apply for an e-visa. Is there a skilled worker, is a skilled worker eligible to invest in UK stocks, mutual funds, bonds or ISAs? Yes. Someone has commented on, yeah, so on my video for don't ruin your life with UK FLR visas, where I've explained the challenges of FLRs that everyone is filing to buy time. Someone, Javed, has commented, most are fake, time buying, every category has been abused. Okay. Thank you for your comment, Javed. Okay. Sir, can Home Office conduct interview in retained rights application? Yes, retained rights for EU settlement scheme application where the relationship has broken down. You are applying saying that yes, I have retained rights. They may conduct an interview if they don't believe something that you are alleging. Hello sir, I applied for retained rights 5 months ago. I think it's the same person. Yeah, and didn't get any response yet. Is this a good or bad sign? So 5 months for a EU settlement scheme application for return rights. In 6 months or so, usually you should get some response, but 5 months is quite okay. Maybe if it goes over 6 months, I know EU settlement scheme applications for partners, retained rights, etc., relationship related may take at least 6 months time. So at least allow 6 months till that time. But just the 5 months pass doesn't mean whether it is a good sign or a bad sign. It just means that nobody has picked up your application. It is sitting in the queue. So I want one question, sir. अगर ये स्किल वर्कर वीज़ा रिजेक्ट हो जाए तो उसके एडमिनिस्ट्रेटिव रिव्यू बेस्ट है ये एप्लीकेशन प्रोटोकॉल. So Mariam Bibi is asked in Hindi. I'll just translate that in English. Okay. If a skilled worker application is refused, is it better, okay, to file administrative review, or it is better to file a pre-action protocol? Pre-action protocol. I don't know if everyone understands pre-action protocol. Okay. I want. It really depends on the facts of the case. You can't just file and you won't just get, if you file both of them or any of them rather. There has to be some merits of filing either of them. It depends on the facts of the case. Sometimes both of them may not have any merit as well to file. Okay, yes, Sweeney. I got my costs about with 42K per annum. Can I apply mine and my dependent husband visas at a time? And after applying, is it interview mandatory for all? Okay, so yes, you can apply for you and your husband. I'm assuming you are not in any of the care worker job codes. Looking at your salary, 42K per month. Yes, you can attach your dependent as well. And after applying, is it interview mandatory? It depends on it's a very case specific situation, but Home Office has been interviewing considerable applicants from basically from Asia. If it's an application from India, Pakistan or something like that, they have been looking at every application very cautiously. So that's what I have seen from experience. Where are you filing from? Which country are you filing from? What is your job code or what is that you will be doing? there are high risk areas, retail sector, etc., etc. It depends on your sponsor's compliances also, how good your sponsor is. Are they compliant? Do they have any negative marks on their sponsor license? So a lot of factors. But so interview is not necessary. It depends on many factors. So, but I would say 50-50 chance of an interview. Okay. So I've just gone past 60 minutes. Okay, so we are coming towards the end of this live. I had promised I'll give some updates. Let me go where those updates are. Where are they? Okay, firstly, e-visa steps. So I'll talk on about 4 points over here. E-visa steps before you travel, graduate route, visa refusal, something new that has just come to light. Updating nationality on e-visa. Section 3C, filing applications within 14 days of a previous refused application, how it affects your Section 3C leave, overstay, 10-year long residence, etc., etc. So first one I will take is e-visa steps before you travel. Okay, before I start, there is a live question. Dheeraj, my company is ready to sponsor, but I am not meeting the salary threshold. Is there any way to get the skilled visa in any way? Is there any other option for the companies? No, there is no option, sorry. Okay, so coming back to the updates, e-visa steps before you travel. So Home Office has published a page. I will try to put a link. Let us see if I can do that. Is it gone? Copy and okay, so I have put that link over here. So this is some latest page email that has come. It details about check your e-visa is correct before you travel. There are a lot of issues at the back end that are happening. Sometimes someone else's picture is seen on your e-visa. Sometimes different status is shown, end dates are different. A lot of entangled statuses are coming up. So it is the government, the UK government has advised on this link. You can read it. They've explained it on different pages. If you're traveling out of the UK, if you're traveling to the UK, you have an e-visa. If you are traveling to the UK and you don't have any visa, they've given all the options. So before you travel, you should check your e-visa has all the correct details. That is your status, expiry date, your picture, etc. If there's an issue with your visa, there are steps you can take. So there is also a helpline that has started. It should come below. Sign into your e-visa account. I put the link over there. Maybe mostly everyone should be able to click on that. I'm just going through that and just discussing the points that they are referring to. And your e-visa is linked to your current passport. So make sure your current passport is updated. You will still need to carry your current passport or travel document. You should also get a share code. So previously this was not the case. Government never, initially even the last 1 year, this share code thing, in the last 1 or 2 months only we are hearing from UKVI that they are recommending that you get a share code. So same way let's say you do a right to work check, you show it, give the share code to your employer. You do a right to rent check. For that you generate a share code, you give it to a landlord. In the same way, to the carrier, to your airlines, whichever carrier you are coming to the UK, you should get a share code to prove your immigration status. The link is there. If you click on that, it takes you. Before you travel, your carrier may ask to see it. A share code is valid for 90 days. So before you're traveling, generate a share code and you can take a printout of it or just have it on the phone or something. Printout is recommended. I think you can just give it to them and they can put the code, etc., and find your status. This is, yeah, in the past, Home Office was only saying that you carry your passport. If your passport is updated, then the carrier will see it. But now this is a new thing that they have added up. I'm seeing this only in the last 1 month or so, I think. The share code aspect, where you generate a share code that shows your status. So they put the share code, your date of birth and name, and they see your status on their systems. And other details are there. So before traveling to the UK, make sure your e-visa details are correct. Very important. You will have problems traveling at whenever you're boarding the flight. Inside the UK, it's fine. The Usually the immigration officers will find you somehow in the system with your fingerprints or something. I don't think that should be an issue. But then definitely check your e-visas before you travel. That is home office recommended, and use this link. They are given a lot of information on that link. Graduate route visa refusal. So yeah, there's something new that has come to. I was having a consultation, I think yesterday or day before yesterday, with someone, and the individual told me that uh, his graduate route visa was refused. So he completed the course of study before the date of application of his graduate route. That's what the rules require him to do, and he's not. And the university did not notify home office. This is quite new. I don't know if it's an overzealous caseworker trying to be difficult. So the course was completed only, and once, so this is the immigration, this is what the immigration rules require. Every university, they notify home office. Once you complete the course of study, they send a notification. They have an internal system directly linked to the home office. They send the list of students who have completed the course of study, and that's how home office already has a record before even your graduate application is filed. So once your course is completed, the record, the UKVVI is sent the notification from every university. I have sent that several times, where universities also forward that email to the applicant saying, oh, we've already notified, below is a copy, something like that. So that notification goes for every student who has completed the course of study successfully. In this case, the university did not notify. uh, I don't know what the reason was. And after that, uh, when the application came to the caseworker, graduate route, they contacted the university to confirm, has this person completed the course of study? They said, yes, this person has already completed the course of study before the date of application. They also confirmed the date. But the caseworker refused the application. This was fairly new. I've never seen that before. I think the person did the application himself or something. And they refused the application, saying the university did not notify the home office before the date of application. It's a common one. I've never seen this before. I am assuming this is just a one-off situation that has happened. If such other situations do come, if anyone watching this live, even in this live or later on once it is saved on YouTube, if you do watch, if you are having in such situation, please do write and in the comment section of any video and just let us know, update us what is happening, because that helps others, where I can update others as well and tell them what is changed. But that doesn't make any sense. If the person has completed the course of study, if the university did not do their job of notifying, that should not affect the graduate route, the student. So it is not in the spirit of the immigration rules. That's what I would say. And it may be just some untrained caseworker or whatever is the case. It is just a one-off mistake, I am assuming. So this is something new, so I just wanted to update on it. Make sure, so the moral of the story is, make sure you check with your university that your course completion has been notified to home office. Yeah, so before you file the graduate application, if you completed it successfully, make sure you do check with your university that they have. And sometimes you can also ask the admissions officer, whoever is dealing with it, to send you a copy of that notification. Yeah, they do send that email, they forward it to you. So yeah, that is just a learning from this experience. The third update, updating nationality on your e-visa. So this is a common question that I have been asked. If you have your e-visa, let's say you are in the UK on any visa, student visa or graduate visa or any other visa, and you have some nationality of some country, X country, and later on you do obtain another nationality of some other country, okay, then you can go and update that nationality. In the past, when there were BRP cards, you were required to make a new BRP application, change of personal details. For example, your name changes, your date of birth changes. I've never seen date of birth change, but yeah, it does change. So name changes, usually for marriages and all. Then you are required to file an application with the new name and confirm to home office and get the new document in the new name. In the same way, if a nationality changes also, the similar application was required to get a new BRP. But currently there are no BRPs, there is only e-visas. So if you are changing anything, you can go and change on the e-visa. Let's say your name changes, you can go on it, give evidence of that. Evidence is very, very important. You will have to produce some evidence. If you are changing your nationality or updating your nationality, you will have to give the evidence, a passport copy or something, and do it through the e-visa only. So everything is possible, all those changes are still possible, and it can be done through the e-visa system only. So 3 updates given. Fourth one, before I give the fourth one, there is a live question. Always, I have got PG diploma. I'm applying for course this week, but I have remaining 8K fee. Will Home Office inquire university about fee? My course duration is completed. I don't think Home Office would inquire about fees and all. I don't even think that they have any jurisdiction to ask all of those things. I think the only question that they would ask you is, give us the proof of course completion, and that's where you may get stuck. I'm not sure how that would work. You can produce a copy of your CAS letter saying the course end date has passed, but I'm not sure what is your status. Are you a suspended student? They have debarred you from the university for not paying the fees. They may not have reported to Home Office. What is your status in the university? That is very, very important. If your student status was maintained till the last date of your course, then I think it's a reasonable case to argue that you completed your course of study. But then if your student status was stopped by them, suspended or anything, whatever the university is called, then you may be in some issues that you were not completed a course of study. That's how I would interpret it. Hi, Mahmuda. Okay, so okay, the last update before I close. Where is that? Section 3C and filing. So just to start with, I'm not sure if everyone is aware of this. So if one of your PBS application is refused, let's say graduate student visa inside the UK, I'm only talking of inside UK applications. If you made a graduate application that is refused, or a skilled worker application that is refused inside UK, any PBS application, points based, then within 14 days, you can make it even for human rights applications. Any application that is refused in the UK, within 14 days of refusal, you can make another application. That is allowed under the section 39E of the immigration rules. But one of the important things, you can make another application that will be considered provided the first one was filed in time, that is before the expiry of your permission. So if you have application 1 refused, within 14 days of refusal of 1, you file application 2, same application, another application, doesn't matter. If number 2 is decided and you got visa, you got a permission from that number 2 application, I'll take example dates over here. So let's say your first application is refused on 1st of January 2025. You make another application within 14 days of 1st of January 2025. You get it approved on 1st of March, let's say. So 1st of March 2025. So whatever this 2-month period is, I'm just taking rough dates over here. So January and February. So whatever that period of 2 months, in this period, you don't have Section 3C leave. That's very, very important. You are allowed to apply. You are an overstayer. If you don't pursue the previous application into an administrative review or something like that, then your Section 3C continues. But if your application is refused and you don't do anything on that application, you just try to use Section 39E and file another application within 14 days, that application will be considered. That's perfectly fine. But from the next day of the refusal, from 1st Jan the application was refused, from next day you are an overstayer in the UK. The overstay period of, let's say in my example, it was a 2-month period of overstay till you get the new approval, you are still an overstayer. You have to report all this overstay throughout your immigration histories, every future visa applications. Second point, you don't have Section 3C leave. You may not have a right to work. That's very, very important. From the date of refusal of your first application till the new application is approved, you don't have any Section 3C leave. And third point is the very, very important point, is about your 10-year long residence. How does this overstay affect your 10-year long residence? Let's say you applied for your first application on 1st of December. Okay, let me just take rough examples. 15th of December you made the application, 1st of January it was refused. So if 15th of December was the last date of your, let's say you were on a student visa and you applied for a graduate route visa. Your student visa expired on 15th of December. Then from the date 15 December till the time you get the new permission on the second application, that is 1st March, you don't have, so that period you don't have any permission in the UK. So from 15 December till 1st of March, so around I think 2.5 months period, you don't have any permission. So that 2.5 periods, it doesn't break your continuity of residence in the UK for the 10-year long residence. It's called as book-ended period of leave, where your permission ends, then there is some gap in between for whatever reasons, applications, refusals, blah, blah, blah. New application is approved. So this block where your permission ends and a new permission starts on the second application, that block of periods is called as book-ended period. It's discussed in case laws and all. So I just wanted to explain this point. This period, there is a lot of confusion around that. It breaks continuity and all. It does not break continuity of residence. It has been tested in the courts of also in tribunals and all, and agreed by judges. So the book-ended period, that is the gap between one leave ending and new leave starting, new permission, that period does not break the continuity of residence for 10-year long residence. But that 2.5 month period in my example will have to be added on top of it. It's called as that period will be excluded from the 10-year count. So you have to do 10 years and 2.5 months to qualify for. So you have to top it up at the end to complete your 10-year long residence. So this is a very important update. I know people usually get confused over this. I know lawyers are also not very sure. So just wanted to clarify that. There are some live questions. I'll take them and then close. Ipu, can I apply for PSW before my exam result? Before your exam result? Yeah, it wouldn't make any sense before getting your exam result to apply for PSW. It is better to wait for your results and then apply. That's my suggestion. When applying final result, I don't understand. So your result has to be out, obviously. Once your result is out, only when your result is out, then your uni will send the notification to the home office. So it doesn't make sense applying before. That is what I understand from the immigration rules. And yeah, so I have given those 3 updates. I've covered all my updates. No more live questions. If you need, for your specific situation, if you need, okay, what is the last point I wanted to cover? Yeah, let's see. Yeah, so if you need advice about your specific situation, you hit the link in the description to book a call with us, either a video call or an audio call to discuss your case. And thank you very much for joining this live. Okay, what is your question? Yashaswini, my question. Where is your question? Let me see. I got my course with 42K. Yes, I did address that if you heard that. So I got my questions. Plan dependent. Yes, I did address your question fully, in full, as soon as it came. Yashaswini, you can watch the answer. This live will be recorded. You can see it then. Okay. And thank you very much for anyone who has joined this live.